Good afternoon and welcome to Naturally Chicago's webinar, Regulatory and Litigation Trends in the Food, Beverage, Dietary Supplement, and Cosmetic Industry. Jim Slama, Naturally Chicago's CEO, will begin the program.
Thank you, Bob. Natural products entrepreneurs focus daily on the practical challenges of building and growing their businesses, but few are experts about the complex regulatory and litigation issues that can create serious and even existential problems. To eliminate these issues and how businesses should approach them, we're pleased to have 5 experts from the Amin Wasserman Bernani law firm share their knowledge. They're one of the leading U.S. firms in the natural products industry with specialties in food, drug, advertising, and intellectual property. Randall Mondry is a partner in the Washington, D.C. office of AWG and co-chairs the firm's regulatory group, where she advises clients in the dietary supplement, food, and cosmetic industries on a broad range of FTC and FTC compliance matters, and will lead things off. Welcome, Rend.
Yeah, thank you, Jim, for that intro. And if we could just get the slides teed up, I will do a brief overview of our agenda today and introduce my co-speakers as well. All right, so here's our agenda for today. As I'm going to kick things off with some regulatory updates and trends at the FDA, as well as the states in California. And then I'll turn it over to my partner, Jennifer Adams, for some advertising law and National Advertising Division updates and trends. Jennifer is a partner in the Chicago office of AWG and leads the firm's advertising practices group. She guides companies through competitor disputes and regularly appears before the NAD and also advises on day-to-day advertising concerns, including compliant claim language and substantiation, influencer programs, subscriptions, pricing, and sweepstakes and giveaways. And then we'll hear from George Spatz, who will cover commercial disputes, claims, and remedies. George is also a partner in AWG's Chicago office and leads our commercial litigation practice, representing clients in supply chain, as well as intellectual property and false advertising disputes. And then next we'll move to Matt Orr, who will cover class action trends and strategies on prevention and defense. I think everyone's favorite topic. So Matt is a partner in the LA office of Amin Wasserman Gurnani and co-chairs the firm's class action defense group, where he advises supplement, food, and beverage clients on a broad range of litigation matters. And then last but not least, we'll hear from Jenny Singh on Prop 65 trends and strategies on prevention and defense. Jenny is also a partner in AWG's LA office. And as the firm's Prop 65 leader, she specializes in helping companies navigate California's regulatory requirements and defend against enforcement actions and lawsuits. I am also pleased to share that having recently tried 2 Prop 65 food cases to winning verdicts, Jenny has a unique perspective on what it takes to successfully defend against the most aggressive Prop 65 bounty hunters. So with that, next slide, please. I'm going to kick it off with an overview of FDA activity and state trends in the interest of time. I'm going to focus mainly on food and beverage and dietary supplements as well. But I will have some brief coverage of cosmetics, but we'll focus mainly on food and supplements where all the action has been last year and looking ahead as well. So I'll do a quick review of 2025. I'm not going to go over everything, but I do have a couple compliance dates that you might want to take a look at and familiarize yourself with those rules and those deadlines. Suffice it to say, I think 2025 had somewhat of a controversial and I think rocky start when it comes to FDA. We had the appointment of RFK Jr., who is, and I have no opinion, but I think it's safe to say was a controversial appointment, and some of the initiatives that he has kicked off have been controversial as well. So he had the initial rollout of the Make America Healthy Again agenda, or MAHA, as we call it. And then we also saw in early 2025 some pretty significant layoffs at HHS and FDA, which led a lot of people to wonder, what's going to happen next, who's going to enforce all these initiatives and things like that. I think MAHA, of course, had a huge impact, continues to have a huge impact, not just on FDA and related agency initiatives, but also the states, which I'll get into. We saw in mid-year the Make Our Children Healthy Again assessment, and then there was a report that followed that, and that discussed initiatives like closing the GRAS loophole. So that is I'm referring to generally recognized as safe, and the ability of companies to, rather than submit a GRAS notice to FDA, be able to self-determine GRAS status for food ingredients, which the law and regulations currently allow. But that has been controversial as well. Ultra-processed foods have been a topic of MAHA, and specifically its role in childhood disease. So we also saw, as part of this MAHA agenda, a pretty aggressive phase out of petroleum-based food dyes. And there has been an ongoing post-market assessment of food chemicals that I think both of these areas are something to watch. The post-market assessment actually started in previous years, but I think we'll see a ramp up of that in the coming years. So we saw at least one color that was revoked, red number 3, revocation of orange B was proposed. And I think there's been some voluntary industry commitments as well to phase out use of these food dyes through the pressure of the administration. We're also seeing authorization of natural food color additives. Several of those have been authorized, as well as new intended uses for those. So that's something to be familiar with, and we might see some draft guidance on that topic. So in terms of what's coming in 2026, a lot of the things I talked about will continue into the coming years. But one big thing that we are looking to drop any day now, I think it got delayed with the government shutdown late last year, is this proposed rule that would eliminate this ability to utilize the self-affirmed GRAS pathway and would mandate GRAS notices. And we've also seen some federal and state legislation that targets these self-GRAS substances too, and somewhat mimics what we think we might see from FDA. But that will be a very controversial rule, and I expect that there will be a lot of comments from industry. We're also expecting a final rule on front of package nutrition labeling and a rulemaking specific to dietary supplements. And we think it's going to target N-acetylcysteine, saying that it is not excluded from the definition of dietary supplement under the FD&C Act. And this is really important because it could lead the way for other ingredients FDA has said are excluded due to being the subject of an investigational new drug application or drug approval. And then who knows, we may or may not see an NDI notification guidance that would get into some of the meatier topics around when an NDI is required, which we've been waiting for almost a decade now. Ultra-processed foods, we might see a definition, a joint effort with USDA and FDA. And then, as I mentioned, I focus mostly on food, but implementation of the Modernization of Cosmetics Regulation Act of 2022, or MOCRA, we might see continued implementation of that. We've seen some guidance come out, but the fragrance allergen rule might be possible in 2026. GMPs were mandated under MOCRA, but we probably won't see that in 2026. And deregulation has been a topic for this administration as well. There was an RFI in May 2025 with a call for ideas on deregulation. We'll see if any of that plays out. We did see one really important movement for the dietary supplement industry, which is that FDA may amend the DSHEA disclaimer requirement to not require that FDA disclaimer on every panel where structure function claims appear. And I'm excited about that. That is something the industry really wants. And our firm is actually responsible in getting this on FDA's radar. Next slide, please. All right, with the states, just as much, if not more, going on with the states. A lot of MAHA-inspired bills targeting synthetic color additives, ultra-processed foods, and what we might call artificial or synthetic ingredients. We saw 2 states with laws that would require warnings on foods containing certain ingredients and food dyes. The Texas AG had investigated and settled with some food companies over allegedly deceptive marketing of products as healthy when they contain some of these ingredients. And we saw several states banning certain ingredients and dyes in foods served in schools. And some of those states are taking it even further, to make it a statewide ban in future years. And I have some of the ingredients listed there that have been the target of these bills. And I also want to mention California, always a trailblazer, now has set its sights on what they're calling ultra-processed foods of concern, and they had passed a law that would seek to restrict those in schools as well. We are also seeing some legal challenges to some of these state laws. That's something to monitor to see how those play out, how those affect future states, and whether that will prohibit them or discourage them, I should say, from introducing similar laws. But I think we're still going to see a lot of bill introductions on all of these topics that are mentioned. I also want to do a quick mention of California's law requiring uniform best by and use by dating on food and prohibiting sell by date labeling. That actually goes into effect in July of this year, 2026. So make sure you have that on your radar and take a look at the requirements. Also, several laws ahead of FDA's Closer to Zero initiatives, which was really focused on heavy metals and baby foods. We have several states, again in California, leading the way to require heavy metal testing for baby foods. I think there was also a Texas AG investigation into that as well. And then California, as usual, taking it a step further, requiring heavy metal testing on prenatal multivitamins and also disclosure of those results. And I won't get into the last bullet point in much depth, but if you're not keeping an eye on EPR programs, which are extended producer responsibility programs, which shift recycling cost and product life cycle burdens to product producers, you should have this on your agenda. There's numerous state bills and laws implementing these programs. Some deadlines have already passed. And we're also seeing a big uptick in states restricting PFAS in a variety of products, ranging from food to cosmetics. And with that, hopefully I didn't go over too much. I'm going to turn it over to Jen, who is going to give us some advertising law updates and NAD updates as well.
Yes, thank you, Raj. That was, the states are always up to something. It's hard. There's too many of them, too many to keep track of. If you thought you could kick off 2026 without a presentation talking about AI, you were wrong. That's one of the biggest trends we're seeing in advertising law right now is the use of AI generated content. It's everything from stock images you're putting in TikTok posts to, I had a post come across my desk the other day that was ostensibly a doctor speaking, talking about the benefits of a dietary supplement. And they were like, actually, that doctor's fake. This is entirely an AI generated person. And that was the entire marketing campaign. So as this continues to evolve, we had a first of its kind law out of New York as a early Christmas present or early holiday present. For once, it wasn't California, but New York has a law coming into effect later this year that requires a disclosure when synthetic performers are used in an ad. A synthetic performer is essentially anyone who is AI generated that looks like a real person, but is not recognizable as any identifiable person. So if you made an AI creation of Kim Kardashian, you're technically not in violation of this law, but you will probably get a letter from her if you don't have permission. But this will require clear and conspicuous disclosure on the law or on the ad that you're using that performer. Of course, we're not told exactly what that will be, what disclosure language you need, but we've been building some tools and resources based from FTC guidance and NAD guidance on disclaimers and other situations that will likely be dispositive. So we expect a lot more to come in the AI space in 2026, particularly at the state level. And it's also an interesting layer to this because beyond the legal layer, there's also consumer trust and perception that is coming with AI generated content that businesses do need to stay on top of. And even without legal requirements to disclose the use of AI, we've seen instances where failure to disclose has been viewed very negatively. There were a couple of clothing brands, namely J. Crew last year, that used an AI generated campaign without disclosing it, and they got a lot of negative press about that. So I think the actionable item is you need to know where you're using AI in your advertisements. You need to have an AI policy, particularly if you're using a third-party ad agency, because they could be making AI generated content and not tell you, but you're still liable. So definitely need to keep an eye on that and take a gut check in 2026 and put the pieces in place now to understand where you're using AI in your business and in your advertising, and how to make sure you're doing it appropriately and within the disclosure guides. The other major advertising update and trend we're seeing, this was throughout 2025, and as we learned today, is going to continue into 2026, but subscription programs have been a very significant FTC enforcement action. We had seven major FTC actions on subscription programs in 2025, including the eye-watering $2.5 billion settlement with Amazon over its Prime membership enrollment and cancellation procedures. Multiple times in the past couple of months, the commission and various commissioners and directors at FTC have said in various speeches and press releases that kitchen table issues are the priority for the commission right now. Things that are hitting consumers' bottom line that they're talking about at the dinner table are a major concern for them, and subscription programs being charged fees without knowing or not being able to cancel them fits squarely within that agenda. Just today, we got an announcement that FTC filed another challenge against a company called Just Answer, that again about subscription and cancellation policies. So hand in hand with that, California has a law that went into effect in July as well that has significant teeth and updates of what you need to be doing, such as getting affirmative consent at checkout, and in fact, regulating how many questions and steps you can have at the cancellation process. This dovetails really well into Matt will be talking about later class action trends. We're seeing a lot of activity there as well. And then just to focus on maybe some more, none of these are necessarily food and natural product specific, but they are very much affecting the entire marketplace, including these products. But pricing claims and discounts are a perennial target you see NAD challenges. We've seen quite a few arise in those. State attorney generals will look at these, your competitors will look at these, but there are often forgotten about, but a lot of laws particularly at the state level that dictate how you can calculate your sale pricing, that you can't make an artificial urgency, order in next 24 hours, but then your 24-hour ticker keeps restarting every single day. Even we've seen this come up quite a bit recently as reference pricing. When you do a strikeout and you say that you're getting X amount of money off, where's that reference price coming from? Could be a number. We've seen a lot of issues of that, of people pulling inflated items from somewhere else to make it look like a bigger sale. So definitely take a look at your pricing policies as well and where you're getting those from. Last one, green claims, greenwashing. A couple of years ago, this would have been at the very top of the chart. It's kind of, I don't want to say fallen out of favor. It's still very much a very concern, and we see challenges at NAD around it. We see certainly consumer interest in it. But as companies have moved away from general greenwashing claims and have been focusing more on specific claims like PFAS and other contaminants, we've seen kind of a decrease in these sort of enforcement actions and challenges, at least at the advertising level. I'll let Matt speak to the class action level. The one thing is we were supposed to, as of 2022 or 23, there was grumblings that we might get a new green guides from FTC to update it was 10 years since the last update. We thought we were going to get an update. There was even some meetings. So far, the current Trump administration's commission has said, don't hold your breath. It's not an agenda item for them. They're focused on other things. So takeaway from this is we still need to be careful about green claims, be careful of your broad claims, but as you get more specific, be concerned about your substantiation and the implied claims from that. With that, I am going to kick it over to George for some business and contract disputes.
Thanks, Jen. I appreciate that. In 2025, we've seen a steady diet of commercial disputes. all up and down the supply chain, from materials and ingredient suppliers to manufacturers to brands. Not surprisingly, most of those deal with breach of contract, breach of warranty claims, which are governed by UCC Article 2 for the sale of goods. One of the things that we've litigated quite a lot this year, and is a call out for people in procurement and supply chain to pay attention to, is the battle of the forms. And that is under the Article 2. You can make a contract in any way that's reasonable, and that includes receiving a purchase order and then performing. So if you're dealing with purchase orders, if you're dealing with sales acknowledgments, look to see if there's references on there to the incorporation of general terms and conditions on the supplier's website, on the brand's website, because if you don't look at that and object to it within a reasonable amount of time of getting it, you may be agreeing to something and agreeing to terms that, one, you don't know about, and two, you wouldn't otherwise agree to. With that said, the claims typically revolve around express warranties. When you have your description of your product or description of goods you're purchasing, make sure they're as descriptive as possible. That creates express warranties that go to the basis of the contract, and are often the specifications and the claims that are going to be sued upon if there's non-conforming goods. The UCC also provides for implied warranties, the biggest one being the implied warranty of merchantability, if it's not excluded in a written contract. That basically means the goods have to pass as they would under the trade. So if they're, again, non-conforming goods, that has led to a lot of litigation. I've called out separately here recalls. We've had a lot of recalls in 2025. Interestingly, a couple of them have dealt with written contracts with express warranties that a manufacturer will comply with all laws, which brings in elements of preventative controls and GMPs under 21 CFR 117 for food and 111 for supplements. Also of note is the UCC provides for the seller's remedies and buyer's remedies, if not specified in a written agreement. And within that, for a seller, allows for stopping delivery, withholding delivery, damages for non-acceptance, including lost profits and incidental damages. And similarly for the buyer, the value of non-conforming goods, the ability to purchase substitute goods, but also get incidental and consequential damages. So those incidental and consequential damages are anything that's not direct, things like expense, inspections, transportation, storage. And so those can greatly increase the exposure in a lawsuit. So those are something to pay attention to. We've also seen pull out a couple competitor claims that we've dealt a lot with. We've had a lot of false advertising claims between competitors. The Lanham Act makes literally false and misleading statements illegal. Here, it's a little different than FTC enforcement and other regulatory enforcement, in that the plaintiff has the burden of proving a claim is false. We can't just claim that the other side lacks substantiation in a competitor claim. Although comparative claims and superiority claims that suggest or disparage the other company's products can be held to a bit of a higher standard. In that area, we've seen just a ton of cease and desist letters and disputes over comparison charts. It looks really nice to have your product with check marks all across it and all your competitors' products with big X's in certain categories. But those lead to issues with superiority claims, comparative claims, as well as trademark issues. You're not allowed to use another person's trademark more than necessary to identify them. So if you start using your competitors' logos, you can get a cease and desist as well. Finally, a couple things we've seen in online marketplace disputes. There have been more letters and actions by unauthorized sellers when brands do Amazon takedowns, Shopify takedowns, asserting the first sale doctrine. which basically says once you sell a product, you no longer can control the intellectual property associated with it, like trademarks. The exception to that is material difference. If the product is altered or mutilated, if it doesn't come with warranty or other services that the brand provides, there's a possibility of an exception there, and that we've seen a lot of litigation around that. Also in this area, we've seen an increase in distributor John Doe suits, where brands will sue unknown distributor, saying that they're breaching their agreement, that they're not allowed to sell to unauthorized sellers, and then issuing subpoenas against unauthorized sellers to figure out where the leak in the supply chain is. And those have been favorably viewed by the courts in enforcing subpoenas. And then finally, we've had a ton of domain name disputes with mirrored websites and typo squatting, some issues with credit card phishing, putting up fake sites and taking customers' credit cards. The claims and remedies for that are varied depending on the severity. You can file UDRP actions, which seek to gain trademarks that are used as domain names. That typically takes about 40 days in the event of a default. If you need to take action faster, we can do a temporary restraining order. And then with the online marketplaces, there are varying degrees of responsiveness, but you can make infringement complaints and abuse complaints when you're dealing with things like mirrored websites and fraudulent websites. And with that, I will turn it over to Matt to talk about class action trends.
Thanks, George. So I've got 5 minutes to go through a host of litigation threats that we all face and we all deal with. So with the nod to Fast Money on Family Feud or Jim Cramer's lightning round, I'm just going to go zip through these and go through some of these risks, and we can certainly talk about them in greater detail if you want to reach out or whatnot. But the one area that's still remains constant is this microcontamination threats, and we see that through a variety of different products, categories, and supposed contaminants. And it doesn't matter if these contaminants are naturally occurring lead or cadmium in cocoa powders, those types of things. There's still threats that we're seeing a lot of our clients get demand letters on and litigation, the mitigation risk there, or mitigation approach, is obviously to test your products and don't assume that just because the contaminant level falls below Prop 65 level that you're okay, because we're seeing these claims even when the levels are below Prop 65. But just as important as what's in the product is what's on your label. A lot of times plaintiffs are looking for a hook on your label. If it says pure or clean or something similar to that, you're going to be a target for these types of claims. Fortunately, we're seeing PFAS kind of fall off. There's not as much PFAS litigation recently. I think that has to do with the fact that there's been some good rulings from judges recently that have identified really the shortcomings in a lot of these PFAS testing that's out there. So we can at least appreciate that. George, next slide. Now, again, just go through really quickly. If you've got malic acid, ascorbic acid, citric acid in your product, and you're making any type of a flavor claim or all natural flavor or no preservatives claim, we're seeing just still a host of these types of claims. And we've been litigating these for years. They're generally frivolous claims, but they get past the motion to dismiss stage. And that's really what the plaintiff's lawyers are looking for here, is just a quick money grab with the cost of defense. We are seeing cases if you've got probiotics in your product, and you also fibers or prebiotics and sugars. There's a poppy case that settled that has really kind of churned the water there. And if you've got kombuchas and whatnot with sugars in them, there's a group of plaintiffs who are seeking claims there, bringing lawsuits and sending demand letters. We saw a big uptake in place of origin cases, primarily made in the USA. Abbas Kazaruni has been in a lot of newspapers and thinks he's the king of made in the USA. If you are making a made in the USA today, I'm sorry, made in the USA claim, really take a close look at your ingredients and your packaging. A lot of our clients are moving away from pure unadulterated made in the USA claims and going to, sourced with global ingredients type claims. We still see a lot of protein cases, percent DV. If you're making a protein claim on the front of the product, particularly if you're using a plant-based protein, you've got to have a percent DV on the back that takes into account the digestibility of that protein. Still seeing a lot of those cases. Seeing some overage cases, vitamin D, melatonin, some underage cases in berberine, some of those types of things. So again, just test your products and don't rely on certificates of analysis from suppliers. It's really important that you do your own testing and that you confirm the quality and the sourcing of your ingredients. Slack fill cases continue to arise. They've been around for a decade and they've just been up and down. And right now we're on an uptick where courts are allowing these cases to get past the motion to dismiss stage. There are ways that we can mitigate against that risk. You can use a fill line. You can do number of servings on the front panel of the product. There are ways to mitigate your risk, even if your packaging is a little bit bulkier than maybe it needs to be. There are some ways that you can mitigate your risk there. Again, these are cases that are very defensible, but courts have recently been allowing them to go past the motion to dismiss stage. We go to the website kind of cases that we're seeing as well. There's the ADA website cases. There's also privacy cases with the California Invasion of Privacy Act. These are metapixel cases, trap and trace law, criminal statute that's been misappropriated to attack companies that, these websites capture an IP address of someone that lands on the website, and plaintiffs claim that that's a violation of some of these consumer protection statutes or these privacy statutes. The trick there is to make sure that your cookie policies are up to date, make sure that they're robust, that they're opt-in policies, and also make sure that your pixels are not firing until a consumer or a visitor to your website actually addresses your cookie policy. Because plaintiffs will say, even if you got the policy, the minute someone lands on that site, if your metapixel is not disabled, they'll capture that IP address, and that's a potential violation. Jennifer Adams talked about a lot of the other claims that we're seeing, which are auto renew has been a big uptake recently. We've seen a lot of litigation and demand letters on subscription policies. We've also seen strike through pricing, a lot of pressure there. And so that's a big issue that we're seeing. And very recently, some anti-spam act. There's a California statute really originated in Washington, where if you've got a marketing communication by email, and if the title or the array line on that email is at all misleading, plaintiffs are saying that's a violation of a Washington statute and a California statute as well. In terms of mitigating risk on some of that type of thing, obviously make sure that your practices and your subscription policies are in play. But also I think arbitration provisions and class action waivers are important. You have to make sure that you're not changing one headache for another when you're doing arbitration clauses and class action waivers. You want to make sure that that clause protects yourself protects yourself from mass arbitration actions, which we've also seen an uptick on those as well. So you're going to want to make sure that you've got some poison pills in your arbitration clauses so that you're not running afoul or run subject to mass arbitration. And then, again, some of these ESG and green claims, plant-based is still really big. When you're using some of these claims, identify how much plant-based, what that means exactly, identify that on your labeling. And again, if you're using biodegradable or compostable claims, make sure that those products can actually be, or that packaging can actually be recycled. And with that, I'll say there's a whole lot more, but I'll turn the time over to our Prop 65 expert. Jenny, go ahead.
Thanks, Matt. Let's jump right into everyone's favorite California statute, Proposition 65, which does impact your business regardless of where it is located if your products are sold in California. Fun fact, we can thank California citizens for voting Proposition 65 into existence way back in 1986. So while it is over the hill at nearly 40 years old, it is certainly showing no signs of slowing down, and in fact, to the contrary. So getting into the latest trends and happenings, increasingly enforcers are targeting the food, beverage, and supplement space. Heavy metals definitely continue to lead the charge, lead being at the top of the pyramid, cadmium, mercury, arsenic. And hate to be alarmist, but truly, if your products include, if the foods include ingredients that are sourced from the earth, sourced from soil, it has and likely will be targeted for an enforcement action. Right now, heavily targeted are protein powders and bars, thanks to the recent Consumer Report publications. And then really any food that includes protein sources are also being targeted, but nothing is sacred. Seeds, cocoa, spices, noodles, cookies, greens, supplements, drinks, you name it, all being regularly targeted of late. Also, keeping an eye, unfortunately, unlike what Matt said, we're still seeing a lot of PFAS and PFOA in Prop 65 actions. The really challenging aspect of that is that the agency that oversees Prop 65, we call it OEHA, they have not set a safe harbor level for PFOA or PFAS. What that means is once a plaintiff has filed one of these actions, it becomes very hard to defend because we don't have a bright line under which a warning is required. So that's something to keep in mind. Also, on the radar are phthalates for food containers and wrappers. Not to forget the personal care aisle, although I left it off of my slides, the attack on DEA and all variety of cosmetics is ongoing, and OEHA has proposed a safe harbor NSRL, which is relatively high according to many members of the industry. So there is some ongoing pushback with that. Also worth everyone's attention is OEHA's recent confirmation that chemicals in items accompanying consumer goods are also subject to enforcement actions. In this case, it has been BPS and thermal paper. So what that means for manufacturers, distributors, packagers is keep an eye on your packaging, inserts, receipts, manuals, tags, and make sure they are phenol-free, BPS and BPA. Nothing new about this one, but small businesses should continue to beware. Bounty hunters are using retailers more and more often to loop in otherwise exempt small businesses. They're just doing it more and more aggressively, coming up with neat little ways to really muddy the waters and rope small businesses into pretty complicated lawsuits. So what I tell clients is even if you are under 10, consider reviewing your product line as if you are not exempt to avoid potential enforcement actions. And finally, the short form warning amendments, those will go, the deadline for complying with those is January 2028. There are several changes that we could, of course, go over with you in detail, but they essentially render the short form warning not so short anymore. But the good news is that they are officially now endorsed for food and dietary supplements. Formerly, they were not, so at least that is some clarity there. Moving on to the final slide, I always tell our clients that Proposition 65 is really less about compliance because there are no testing requirements and there are no reformulation requirements. And so really much like litigation, your class actions, it's really more about risk management and mitigation. So What can we do to reduce risk? Just like Matt said, we can conduct exploratory product testing to determine if displaying warnings is a prudent idea. To do that, we're going to review your high-risk products for high-risk chemicals, evaluate serving sizes and serving suggestions, both very important. And then we compare those to the safe harbor levels to determine if using plaintiffs' very conservative, I would call it bogus methodology to measure exposure, whether we're comfortably below those bright lines or not. We can also implement a more robust lot by lot testing program. This can be helpful to provide peace. It can also, or peace of mind rather, it can also provide a potential defense if a notice of violation is issued. We can use it to dispute plaintiff's product testing. Big caveat there, though, is that one passing test report does not necessarily create a walk away from plaintiffs. A lot of the plaintiffs are, again, very aggressive and will not necessarily retreat with one passing test report, but it can certainly be used in the defense. Other considerations, let's look at defense and indemnification agreements with upstream entities and suppliers. And if you do decide to display Proposition 65 warnings, it's really important to make sure that the language, placement, size actually meet the clear and reasonable safe harbor requirements. Many times enforcers actually come after companies for improper or insufficient warnings. Also important is to notify retailers that warnings are required if they're on the product. They should be online as well. So there's a lot of nitty-gritty elements of that notification that we are happy to help you with. Finally, if you are issued a 60-day notice of violation, do not ignore it, please. It's tempting, but it can be really beneficial to address it right away with your counsel and investigate and get moving on a defense. And with that, I think we've come to the end.
Wow, that's a lot of information. Team AWG, we're very grateful for your abundance of knowledge. And George, if you can switch over back to the previous deck. If people do have questions, please put them in the Q&A button, not the chat. Just a little bit about Naturally Chicago. We invite you to become a partner, specifically a brand partner. We connect our partners with all of our retail partners, Whole Foods, Fresh Time, Mariano's, Walmart, Costco, some of the biggest buyers in food. And plus, we have a mentoring program. We've got 75 investors in our network. So Natural Chicago is definitely a worthwhile investment for those who are interested in continuing to grow their business as a brand. Next slide, please. Tomorrow morning, we have our first morning mingle of 2026. It'll be at the French Market, downtown Chicago, 8 a.m. to 9:30. We hope you can join us. And I think that's it. So I've got a couple of questions, and then I'd like to move to some of the audience questions. So don't forget, if you have questions in the audience, please use the Q&A function down below. So Ren, how would the proposed GRAS rule impact self-affirmed GRAS ingredients currently on the market? And does the FDA have the resources to monitor compliance and enforce the rule?
So those are really great questions. And I think given there are so many self-affirmed GRAS ingredients on the market being used in both foods and dietary supplements, I think it's on a lot of our clients' minds. Unfortunately, we don't have the details yet of what FDA's proposal will contain. There was a bill introduced in Congress by Congressman Marshall. And I'm blanking on the number. I think it's 3122. But that contains some details which we think might end up in the proposed grass rule. And what we believe might happen is that there would be a grandfathering in of currently self-affirmed grass ingredients, whereby information on those ingredients, just the fact that they are self-affirmed grass, would be notified to FDA, not in a like a formal grass notice, but at least FDA would be aware of those currently self-affirmed grass ingredients. And then it would be for any new ingredients that are purported to be grass, those would be subject to mandatory grass notifications. But again, this is just speculation on my part. We don't know the exact details at this point, but we think they might be dropping any day now. In terms of FDA's ability to police the ingredients, I mean, that's another a big question mark here. I think certainly having a grandfathering provision for current ingredients on the market would relieve some of that burden. But we have an FDA that even before these layoffs that happened and some people came back, I mean, has been understaffed for decades, right? And it's an agency in charge of so much. How do they police? I'm not sure, but then we have states stepping in and having their own proposals targeting these ingredients. So it's possible that even if FDA isn't able to enforce and monitor, we're going to have the states doing it in multiple ways, whether it's through legislation or even class action plaintiffs could get in on this activity and enforce. And I just want to do one plug really quick. I know I went over everything really quickly, but we do have a regulatory roundup, which you can sign up for at awglaw.com. And that covers a lot of what I talked about. It covers litigation trends, advertising trends, Prop 65, everything. And so that is where we keep our clients and just the general public updated in terms of what is going on in really all of the areas that I talked about. So please visit our website and you can sign up for that and hear more.
Great suggestion, Ren. I got a copy today and it's very informative. So thank you.
Yeah.
And Ren, how have the FDA's enforcement priorities shifted under the current administration?
So far, I mean, I don't know that we've seen a notable change. I mean, I think in terms of the warning letters we see based on that activity, FDA is still, for the most part, focusing on products that are making egregious disease claims, things like that, where there are egregious GMP violations. Really, I mean, it's using their resources in a way that prioritizes products that pose the greatest risk to health. So I don't know that that's going to change. I mean, we do have a lot of new rules and new restrictions coming up. So again, I mean, the question is, does FDA, are they going to have the resources to effectively police all of that? And we don't really know that. But so far, I mean, we haven't seen like a huge shift in enforcement priorities for the agency.
Gotcha. Jen, are there any updates or expectations around FTC's health products compliance guidance and substantiating structure and function claims?
Yes, the claims we all hold near and dear to our hearts. We had the guidance come out in 2022. We haven't seen this administration very interested in it. We haven't seen any dietary supplement or food or cosmetic enforcement actions really coming from them, at least as far as claims. I did have the opportunity here, one of the directors speak at the NAD conference this fall, and someone asked if we would expect an update. And he said, quote, "It is just guidance," and didn't have anything else to say about it. So right now, I think we're stuck with what it is, but at least it doesn't seem to be an enforcement priority. The other side of that coin is it is still law or guidance on the books, and the National Advertising Division is very active in the dietary supplement space, in structure function space, and they do follow it very, very closely. So need to be careful of it that way.
Gotcha.
Mhm.
George, is the current federal and state advertising enforcement environment higher or lower than typical?
Yeah, I think it has been varied with the layoffs. We've seen a little bit less, but there's still a steady stream of investigation demands that we've been seeing, and it has shifted a lot to the state level, and even municipalities and counties in California have been getting involved. So while I feel as if it might have retreated a little bit from the federal level, there still seems to be a lot of enforcement activity being pushed down to states and now even municipalities more often.
Got it. Thank you. So, Jenny, if a product requires a Prop 65 warning, does it need to be displayed both on the product and online?
Yes, although the regulations are a bit confusing when you parse them out. OEHA, the agency overseeing Proposition 65, recently provided guidance on that, explicitly stating that it needs to be both on the product and then also online prior to purchase.
Got it. All right. So for Matt, Joe Stanzione asked, can you elaborate a bit on what the overage cases are targeting? Too much overage, not enough? You answered that online, but
Yeah, yeah.
to the audience.
Yeah, you bet. I mean, what I've seen, vitamin D. There have been some really public melatonin cases. And it's, obviously it's an awkward situation, right? Because you've got to have your product formulated so that it complies with the FDA requirements, that it have, the full amount of product at the end of the the best use by date or the expiration date of the product. So these are claims where the plaintiffs are claiming that the product has so much in it, even at the expiration of the product, that there's a potential for risk or harm. And they, the consumers pointed in the melatonin cases to some potential harms that could occur there. And I've seen, again, some of the vitamin D cases where they make the same kind of claim that there's a danger or risk of an adverse health event. I've also seen some sodium cases, frankly, where there's just potentially too much sodium in certain products, certain foods, and I've handled those as well. So, and then there's always underage cases, which are protein shortfall, handling a berberine case. There's been some berberine cases that are out there. Some other types of cases like that.
Got it. So we have a question from an anonymous attendee. Have there been any defenses regarding Prop 65 raised regarding bioaccessibility? A supplement bioaccessibility may be lower than foods or beverages. That's an interesting question. Anybody want to jump in on that one?
So I haven't seen this specifically litigated under Proposition 65, but it could certainly be incorporated into an exposure defense where the company or the defense is essentially saying that the average consumer of the product is not exposed to X amount of the chemical based on the absorption rate, or all sorts of factors could weigh in on the actual intake. So I could certainly see it contributing to the exposure affirmative defense.
I think the plaintiff should probably say the key aspect of that is what's the uptake of the contaminant, right, as opposed to the supplement. So if you can show that the supplement somehow blocks the absorption of lead or cadmium, that might be an approach. It's going to be expensive, probably. You'll need expert testimony for that, but it would be an interesting approach to a defense and could be viable.
Great, thank you. Well, I think we're just about at the end of our time. I just want to let the audience know that they will be receiving the copy of the webinar, the slides from the law firm, and then we will be Bob Bennetson, who introduced me earlier. We'll be doing a blog about it, and we'll probably publish that next week. And that'll include links to everything as well. So I see Rakesh Amin is also on. Rakesh is one of the founders of the firm and a Naturally Chicago board member. Rakesh, thank you so much for helping to put this together with your amazing team. We're grateful for all you guys do for both Naturally Chicago and our industry. And I just want to say thank you all.
We
Yeah.
really appreciate the opportunity, Jim. Thank you so much, Bob, and everyone at Naturally Chicago. And thanks to everyone in the crowd.
Yep. And great job, team, again. Bye-bye.
Thank you.